Good morning, everyone. Thanks so much for joining us for our free Thursday webinar. I'm Vicki from LookUpStrata, and I'm also the Managing Director of Talbot Corporate. I'm your host for this Queensland webinar. Today, we welcome Will Marquand from Talbot Corporate and Vicki Freame from Colibri Realty to talk about the relationship between body corporate managers and property agents. Why does tension exist between these two professions? Can they work together in harmony? Are there competing interests, or are property agents and body corporate managers working for the same client? Will and Vicki will discuss regular problems that arise, such as pets, parking, insurance and maintenance, and why these often lead to disagreement. And before we begin, I'd like to mention that the information in the session, including any discussion arising from submitted questions and chat conversations, is not legal advice or financial advice and should not be relied upon as advice. And you should seek independent advice before acting on the information contained in the session. We welcome Will Marquand from Tower Body Corporate. Will joined the Tower Body Corporate team as General Manager and Senior Strata Manager in 2020. A licensed strata manager, he has widespread experience across all forms of commercial, industrial and residential schemes. A formal journalist and teacher, Will is also a regular contributor to LookUpStrata as both a writer and a webinar presenter. He believes in proactive, ethical strata management and hopes to provide Tower's customers with the knowledge and support required to take their schemes forward into the next generation of body corporate management. And we also welcome Vicki Freame from Colibri Realty. Vicki started in the real estate industry around 10 years ago while working for one of Queensland's largest builders. Real estate quickly became a passion, and in September 2020, Vicki made the decision to start her own agency. Vicki is proud of the relationship she has with her owners and tenants alike. So we welcome Vicki and Will to this session today.
Good morning. Hello, everyone out there.
Hi, good morning, everyone.
Thanks for everyone for joining the session today. We thought it would be fun to hear some of the different perspectives of how body corporate managers and property managers approach the industry. And if you're a customer out there, this might be something that you don't always get to see, because these conversations are often happening kind of behind the scenes in a way. There's conversations between myself and property management agents over phones and emails that as customers you often don't see. But what you may not realize is that there are often many kind of little flashpoints between agents and managers. And they probably exist because, well, agents do their job. They're working for the individual owner, and body corporate managers, just like me, well, we're working for the collective of all owners. And sometimes those two things don't always agree with each other, and we get little points of tension that arise. Vicki, I don't know how do you feel about body corporate managers in general?
Look, in general, my experiences have been quite good, but I do think that comes down to having a bit of an understanding of the difference between your job and mine. In situations I've had in the past where maybe we haven't had the strongest relationship with a BCM, we do definitely have a lot more conflict and a lot more disagreement about whose role is what. So based on that, I've always personally had a bit of a drive to have a good relationship with the BCMs, but also with owner occupiers in complexes that we're in. I think it's really common in a lot of complexes when you've got a mixture of owner occupiers and investors in there that often the owners aren't really keen on seeing renters in their complex, and they can have misconceptions about what that means for their complex. So as a property manager, having a bit of a relationship with those owner occupiers in the complex as well as BCM can often eliminate a lot of that tension. So definitely something I've learnt the hard way over the years. But yeah, I think it's definitely important that everyone's sort of working together for the same common goal, but it doesn't always work that way.
I think that's true, isn't it? Quite a lot of, especially owner occupiers, do have a sort of negative view towards tenants. And I think that they feel that they look after their property, whereas tenants just come in for a year or two and they just don't care and they let it go to seed. Is there truth in that argument?
I don't believe so. Look, I know personally on my rent roll, I've got tenants that have been in the properties long term. They look after it like their own. If you walk through a complex or you drive past a property, you can't pick the renter. In a lot of cases, tenants, they want stability, they want long term. They don't like having to move every year. I don't think it's a fair assumption that owner occupiers make. And I think that as property managers, it's part of our job with having that relationship with those owners to explain that to them, but also to demonstrate it by the choice of tenants we're putting in properties and making sure that the applicants that we're presenting to owners as suitable candidates are a good fit for the complex and for the property. So an example of that is, if you've got a 3-bedroom townhouse with a double garage and you've got 5 people with 6 cars wanting to share that unit, that's not the property for them. That's not going to end well. You're going to have problems. And they might be a great candidate for another property, but they're not going to be suitable for that complex and that property.
You raised an interesting point there about the agent's capacity to put the right tenants in the right building. Do you have much influence over who goes into a property, or is it really just sort of filled up with, who comes through the door?
Well, look, ultimately, it's always an owner's decision. We process all applications exactly the same based on the same criteria. So if an application, meets the affordability criteria, they've got good rental history and, or they're a homeowner previously, that kind of thing, we check all that out. They meet all that criteria and the basic sort of what we're looking for. They're presented to an owner for a choice. But we do, when we present them to the owners, include specific information that may cause problems for them from a body corporate perspective. But I don't think that owner occupiers in complexes necessarily understand and appreciate the work that goes into that tenant selection process as well. So when we get a complex where it's a nice, harmonious environment for everybody, it's good news for me because it means I've got less tenants moving out and unhappy owners. And it's ultimately the goal. That's what we'd like to see in every situation, but it's hit and miss. Sometimes it does, sometimes it doesn't.
And when tenants move in, there's often problems with like bylaw breaches. We were sort of mentioning tenants having too many cars but not enough spots. That's a fairly typical one. Pets and all this kind of thing. When they move in, you're required to give them a copy of the bylaws. Is there any other discussion beyond that provision of the bylaws, or any discussion around this type of scheme, they are going to complain if you're breaching the bylaws, or this scheme they're a little bit more relaxed if you park in your driveway or something? Do you have that kind of conversation, or is it just
definitely do. So I have the conversation as early as the open home. So when we're at the viewing and people we're having that conversation, when do you guys need to move by, how many of you are there, that kind of thing. I do point out, now you do understand this is a double garage or it's a single garage, you cannot park in the visitor parks, etc., etc. So they know that from the viewing. So what I'm hoping with that conversation is anybody that's going to be a problem for just won't apply. We then, obviously, when we send a lease offer out, once someone is approved, they get a copy of the bylaws and they are redirected to read through that prior to signing the lease agreement. That's a legal obligation that we do that. And then again, at the handover, when we give them the keys and do everything, we again reiterate all those key points in the bylaws. What I've actually done for my agency is I've done a sort of like a cheat sheet that is an excerpt of the bylaws that are the main key points that people tend to breach. And I put that in their handover pack. So it's a thing of, about noise, about usage of the pool and common areas, those kind of things, parking, pets, all that kind of stuff. So it's just kind of like, I know we've given you the full spiel, but sometimes that can be a little intimidating and people just scroll and click and go, yep, I've read it. But at least if they've got that little snapshot of the things that we know are key regular problems, it kind of redirects again that this is an issue. And so they do have plenty of opportunity in advance to know that this is something that's going to be monitored and it is something that we will police. So anybody who sort of pleads ignorance down the line, but they don't really have a lot to fall back on really with us. So it's something we try and proactively prevent where possible.
Yeah, sure. I mean, I'm sure you're doing the right thing. Across the industry, do you think that provision of the bylaws is a standard? I know it's a requirement, but do you think it's actually...
Look, it's definitely... I do think within the industry, the vast majority of agents would be including those bylaws with the lease agreement. There's actually a section on the lease agreement that specifically deals with the bylaws as well. So on page 1 of your lease agreement, there is a body corporate bylaws applicable, yes. Has the tenant been provided with these? Yes. So if you've got an agent who's ticking yes and not providing that, they are obviously creating a risk for themselves. And I would think that the vast majority of agents are including that. Having said that, I have found some body corporate managers in the past where obtaining those bylaws when you take on a management is incredibly difficult. I find that quite counterproductive because, one, I don't quite understand why that's so protected, and maybe you can shed some light on that. Or two, like why they wouldn't want to work with us to make sure the tenants have that information. Is there reasons behind why some body corporate managers might be a little bit more difficult to get those bylaws out of?
Yes, usually you might find that the bylaws have already been provided and they are available to owners via a portal or an app or something like that. So some body corporate companies might feel, well, we've already provided this for free. Why should we have to be doing the same work again? And they might take the view of, why are you asking us as the body corporate managers first, as opposed to going to your owner? Why don't you ask your owner for a copy of the bylaws? They can just go on our website, they can download them for free. I think you'll probably find that's the main reason why there might be some reluctance, or why you might find that there's a fee in some cases.
Mm-hmm.
Is that productive for body corporate managers? Probably not, I would say. Ultimately, you want people to know what the bylaws are, right? And if someone's asking for a copy, it makes sense to send them out, because once you've sent them out, you can then make the complaints that people don't know aren't following the bylaws. But if you've got people breaching the bylaws and you're also being restrictive about advising what those bylaws are, you can find yourself in a sort of slightly compromised position. So from my perspective, I think sending out a copy of the bylaws, it's like, it's a 1-minute job or a 30-second job, basically. So I don't really see any issues, particularly with doing that. But I think, yeah, some companies, they might just feel like we're having to double up on all of the work that we're doing, and that's not reasonable for us to be doing. In Queensland, we're about to see a change in the legislation that's basically going to say that all body corporates, effectively you have to approve any reasonable pet application, but there still has to be an approval process. And from a body corporate's perspective, the timeline around that is going to be, well, it's at least up to 6 weeks if you consider a pet application to be an owner's motion under which to approve it. For tenants, I know that is quite a different sort of legal process. Maybe if you could sort of describe the process for them, and then we'll see how that creates a problem.
Yes, so obviously there was some legislative change with the RTRA Act last year that meant that owners can't reasonably refuse a pet application. So the process used to be each individual agency would have a pet application form. They would give it to the tenant. The owner could say yes or no for any reason whatsoever. It could just be, I don't like cats. No, you can't have a cat, for example. Now that's changed. There is a uniform pet application form on the RTA website that a tenant completes. They fill that in, they send it to the property manager. It's a 14-day turnaround. If the tenant doesn't receive a written response within 14 days, it's automatically deemed approved, and the owner can't put any restrictions or conditions on it. They can't withdraw that. They can't block it. There's nothing they can do about it. The tenant now legally has a pet at the property. So where that creates a problem for us is that obviously we take that application and send it through to the owner with, quite firm timeframes on it, saying, I need an answer back from you. When they approve it, they can have the ability to put conditions in place. So, for example, they might say, well, yes, you can have the dog, but you have to have a flea treatment done annually and on vacate, and you've got to have the carpets professionally cleaned, and it can't have any noise and da-da-da. What we tend to put when we have approvals like this in a complex, we also add in pending body corporate approval. Now, whether or not that would stand up in a dispute, we're yet to see, because there's no precedent for that yet. But we're aware that the time frame, like once the owner says, yep, I agree, and here's all my conditions, we then have to get the tenant to complete the body corporate's individual pet application, which again will be different to the one they've submitted to us because you need different information. We inform the tenant that yes, the owner has approved it conditionally based on this, but we still need body corporate approval. So what that then means is we're waiting that 6 weeks or so to get body corporate's answer. But in the meantime, the tenant potentially has that pet on premises. So from a body corporate's perspective, that pet's unapproved. From the landlord and a real estate and a tenancy law perspective, it's legal. So the issue is that when that tenancy law change happened, it didn't line up with body corporate's law change. So, and even when that changes, your timeframes aren't going to line up with ours. So it's going to constantly be a case of there is a period of time where essentially a tenant or even an owner in some cases, I guess, would be in breach of the pet bylaw by having an unapproved pet.
Yeah, it's a shame, isn't it? Because you've got two very closely aligned industries, and it would make sense if the rules applied to both of them. You've got 14 days for a pet approval within within tenancy law. Probably 14 days would be a reasonable amount of time for body corporates as well. It's not really that hard to make a decision on the pet approval. From my perspective as a body corporate manager, I can present the information to committee members within a day or so. We've got tools that they can very quickly make a decision on, and you could get a return within that 14-day period, no trouble. Just the body corporate legislation doesn't really look at it that way. It gives the committee a much longer period of time, and depends on the committee, but some people might say, okay, well, we're going to have our committee meeting next month and we'll make the decision at that point. But that could mean the tenant's waiting for 6-8 weeks or so for a response. And of course, you get quite a lot of problems coming out of that, right? You're going to get angry tenants or people who can't move in because they're waiting for a body corporate to respond. I think for body corporates, though, there's a lesson here, isn't it? It's that the tenants are now basically, the default position is your pet is accepted. So if that's the default position, they're expecting their applications to be turned around fairly quickly. And if you have an objection to an application, you need to make that complaint fairly quickly as well, because if you don't, then the pet's probably going to be in the property anyway, and then you've really got it's really a long road to have a pet removed, and you're looking at a lot of additional fights. So it's really, body corporates, yeah, you might have the right to wait 6 weeks or more till you approve an application. But if you are waiting that length of time, you're probably causing yourself more troubles than you're actually solving. And if you can, you're probably better off approving pet applications relatively quickly where they're reasonable, or making your objection fairly quickly if you think you've got concerns. Body corporate property managers are required to provide to body corporate agents like me their own details, advising that they're managing the property, and the details of the tenant. But oftentimes that information is missing. We just never get updated with who's in control of the property, who the tenant is. And then when there's a problem, we don't know who to contact. We're often just sort of flailing around wondering who to speak to and what to do next. And that can often be a particular problem. The owner might be unavailable at the time we're trying to contact them, or they could be overseas or something like that. It causes a large issue for us as body corporate managers. I think it's something I've heard major complaints about in every office I've worked in. Why don't you update us with your details, Vicki?
Look, I do think that in general within the industry, it is just a bit of a gap that's just a missed step in a process. There's a lot of steps to taking on a management, getting it leased, all of that kind of thing. And I think in a lot of offices, it's just one of those things that's not thought about. And it's probably assumed on some level that the owner is passing on our details as their agent. And realistically, sometimes, again, we do get pushback. There's been times where I've reached out to a body corporate manager and said, hi, just letting you know, we've taken on this management of this particular unit, and, this is my details. And they're like, we need the owner to confirm. It's one of those things that's just an incidental gap. It's not something that we're deliberately not telling body corporates. And, it's probably not something that body corporates are always actively chasing up, like, on a regular basis with owners to go, hey, it's the, annual update your details time, and can you confirm, all of this sort of stuff. And owners put it on the back burner.
From a manager's perspective, it's our job to maintain the role. So if people are advising us who the agents are and who the tenants are, that's our requirement as part of our contracts to keep the role up to date. So we should always want to have that information and be happy to receive it. And we don't use that information really for anything other than what we think is valid purposes, which is mostly getting in contact with people when there's a problem or an issue. Where we have a much bigger problem is when we can't get in touch with people, when we can't sort of speak to someone, or we can't get in touch with a tenant quickly on time because there's a water leak or something like that. If we don't have those details, then it takes much longer to have a resolution in that kind of situation. Do agents have a specific complaint about body corporate managers? What do you find that they groan about in the office?
Look, I think from my experience personally and others that I've worked with, one of the two key problems, I guess, is in some scenarios, some body corporate managements, they don't have a specific person that you deal with. It's a team or a pod. So you're sending an email to a generic email, and one of three people might answer you depending on who's covering it that day. If you ring up, you don't necessarily know who you're talking to. And so sometimes there can be differing information as well as a result of that. And then on top of that is extended timeframes for replies. So property managers get hammered a lot about our turnaround times on communication, phone calls, emails, text messages, you name it. We get hammered 24/7. Someone will send you, an email at 11 o'clock at night and expect an answer by 4 o'clock the next day because, to them that's a day. And it's not reasonable. And a lot of the times we're waiting on answers from owners or we're waiting on answers from body corporate. And tenants get sick of hearing, oh, I haven't got an update for you. And I can understand their frustration, but we're also not in a position where we can send out an email for email's sake going, sorry, no news yet, we'll get back to you. So a lot of our time as property managers is following up this email, following up that phone call, ringing that person back, trying to get information from an owner or trying to get information from a body corporate. So it can be very frustrating if we're getting bounced around from left to right or that person's on leave, so nobody's dealing with that. And I think that's probably a two-way street. I would think that the body corporate managers probably have similar complaints and experiences with us as property managers with our turnaround time sometimes. So I think it's just the nature of the beast within both of our industries. And again, this is where something like a communal portal where property managers can obtain certain information quickly, application forms or, bylaws and things like that would make both of our lives easier. And let's hope that that's something that happens down the track. But communication, I think, is probably our biggest issue with some body corporate managers.
Okay. I mean, I think your complaint about sort of having to respond to a team and not quite knowing who you're dealing with, a lot of owners, I think, share that same complaint. It's how some body corporate companies operate. There's lots of good reasons why they do it that way, and it's up to their customers to determine if that's a good system for them or not. But I think it is a common sort of point of frustration that we often hear, which is that you call the body corporate company and then you're never really speaking to the person who can resolve the issue for you. And who can give you the direct information. And then if you speak to different team members, of course, the information you get isn't seamless. You get slightly different pieces of information across the board, and it's quite hard to provide that totally consistent approach. I suppose body corporate managers, we've got the same complaint towards agents, because some real estate agent companies, they have a similar type of system. We just sort of send an email to a generic inbox, and I get a reply from one person one day and the next person the next day, and it just sort of feels to us like no one's really taking control of an issue. And you pick up the phone, you're like, can I speak to someone who is in control? And it's like, oh well, they're out for lunch, or someone will call you back later, and then no one ever does. And that is kind of a weakness, I guess, of the team systems that tend to operate in larger companies across both sides of the industry, I suppose. My impression as a manager is that most agents don't really have a very good understanding of body corporate law. just to put it frankly, and you might feel like, okay, well, we're not body corporate managers, so we shouldn't understand the law in its entirety. But I think the view of most managers is that as an agent, you're working in strata title properties all of the time. You're going to be dealing with these issues constantly throughout your career. Why don't you have a better understanding of how bylaws work, how maintenance issues work in body corporate? And I think we feel a lot of frustration that we have to sort of explain what we feel should be relatively common knowledge to agents. Do you think that's a fair complaint?
I absolutely do. And I think it is a massive gap in the training that's provided to property managers. You can go out and do your 3-day registration course to go and work in a real estate, and the vast majority of what you're learning is to deal with sales and things not even related to property management. You then go in to do a full license, and you're talking about, you know, trust accounting and all this other stuff. But there's not really any modules in the training that go in depth into what's involved with body corporate management. So it is a separate thing we can do. But if you're not aware of it and you're not availed to those resources, what often happens is that property managers are, you know, in a big office, they're overworked and under-resourced, and there's not enough hours in the day as it is. So to tack on some extra training about body corporate law is just something that's overwhelming for a lot of agents. I think it's important personally. I've done, you know, some background extra training and gone to seminars and things like that to have a better understanding, because I think it helps me and it helps my team when I've had worked for, you know, obviously other agencies and had people under me, and done in-house training on that, because I do see its importance. But I think as an industry, it is a big gap, and it is something that needs to be looked at in terms of the training courses that are provided in order to get your real estate certificate or your real estate license. And again, that's one of those things where I just don't think the two industries have ever really been aligned, and they should be. And that's something that, you know, governing bodies and things like that probably need to take on board when they're rejigging their modules and looking at what's required for a license. On top of that, we also have legislative changes happening quite a lot within property management. So just staying on top of those things is, you know, a challenge in itself, on top of having to have all this other stuff. I think it's just about building better relationships between property managers and body corporate managers, so that that information is accessible and they understand that it's accessible and where they can find it, so that they can do that research.
I mean, for anyone out there who doesn't know, a lot of body corporate managers do wear both hats of the real estate agent and the body corporate manager. I suppose the argument in favor of that, there's a lot of synergy and ease of communication across the two groups. The argument against that is that it's quite easy to find yourself compromised between your lot and the interests of the lots that you manage and the interests of the body corporate. It's up to individual owners to determine if they think that those models are good or bad. But yeah, if you're in a position as a body corporate manager where you're also a real estate agent, I can imagine there's quite a lot of like professional tension with other agents who might be acting on properties that you manage, because ultimately you want to take their business as the real estate agent, and you that might become your priority rather than doing your job as a body corporate manager. Do you think, is that a reality of what happens?
I do think so, yes. And again, at the end of the day, they're doing it for a profitable outcome. So in any business, when the profit becomes the goal over other aspects of it, it's going to cause grief or conflict somewhere down the line. But I do think it's a natural thing to happen. And that's what, you know, as I said, I can see both sides of the situation there.
Yeah, okay. My last kind of complaint for you is around, it's fairly simple. It's why can't agents evict bad tenants? We often have a situation, and I'm talking really bad tenants here. I'm not talking about people who are, you know, just sort of breaching a parking bylaw or something like that. We often have situations where some owners, but you know, I can't move an owner out, but a tenant can kind of be moved on. We have tenants who, you know, have had all kinds of problems, domestic abuse, drug abuse, and things like this. Very, very serious issues, but it's been very hard for it seems like it's very hard for the owner and the property agent to move that tenant on when they're causing serious disturbance at a scheme. Why is that?
Look, trust me when I say, as property managers, we would love to move them on as quickly as you would like it. But our hands are tied with process a lot of the time. So, you know, once we've received a complaint about something, we need some evidence to back that up. Then we can issue a breach notice that then comes with a time period to rectify that breach. If that breach isn't rectified, it does depend on what the breach is. You know, in some instances, you can just file straight to QCAT for, you know, questionable behaviour and objectionable behaviour, and have it terminated. But in most cases, we have to build a case. We can't just on hearsay, you know, this one neighbour keeps complaining about the same thing. And, you know, a really good example I can give of this is I had a tenant in a completely different complex from the one we worked together on. And one of the neighbours was complaining frequently of a smell of marijuana coming from this property. And she was claiming that the tenant was smoking marijuana out on the back patio. And, you know, it was an issue. Now, of course, we take that very seriously. There was no evidence of any kind of drug use or anything in terms of, you know, when we do routine inspections, which you'd expect, they get plenty of notice that we're coming. But this property had also had a lot of maintenance issues. So I spoke to tradies who'd been at the property and, you know, tried to get some more evidence. And we really couldn't pinpoint that there was any evidence whatsoever. And this tenant, you know, she was a nurse, she was working night shifts. I'm like, I just can't see it. And there was something about it that just didn't buzz right with me. On further investigation, which was actually just a very honest conversation with my tenant, she said that there was a park that was behind her back fence. And so what was happening was these kids were going down to the park and smoking marijuana, and it was wafting over everybody's back fence. So she'd never complained about it because she's rarely home. She works shift work, and when she was home, she was asleep. But when I approached her with it, that was the response she gave me. So when I went back to Body Corporate and said, actually, this is what, you know, our evidence has said, there was actually other people who then came forward and went, oh yeah, I think that's probably the reason. So in that situation, if we'd have just acted and assumed that that tenant was using drugs and taken the path to boot her out, it wouldn't have even floated. It would have just got thrown out of QCAT for a start. So it's really important that we do that research and we do build a case. And, you know, sometimes that does take time. And we have to build that case because once we've sent a breach, once we've followed through with a notice to leave, when they haven't left and we've got to go to QCAT, we've got to prove to an adjudicator that this person needs to go. And wait times for QCAT are getting longer and longer because there's more and more disputes because of various different reasons. But, you know, also, the housing crisis is impacting a lot of adjudicators' decisions. They're, you know, in previous times, they would have, you know, you've built your case, you've got a strong case, it's a wham, bam, thank you, ma'am, warrant of possession, out you go, you've got 24 hours. Now tenants are getting 2 to 3 weeks to move on a warrant of possession in some cases. There's cases where even though there's a strong argument for that tenant to be removed, they're not, that we're not winning those cases. So there's a lot of it that's just out of our hands, and we're equally as frustrated with that because when we get a bad tenant, as you describe, it's more work for us as well. We're dealing with more complaints externally. We're dealing with the condition of the property. We've got to deal with, you know, in a lot of cases, if they're a bad tenant on a number of levels, that you can guarantee they're a bad tenant from a payment point of view as well. So, you know, we're all on the same page about wanting these people out of the property. It's not that we're like, oh no, they're paying the rent, so we don't care. In a lot of cases, they're probably not. But it's the process that we're required to follow that stretches that out and does make it very difficult. And even then, there's often no guarantees. We can put the best possible case forward and still lose a case just because the adjudicator at the time decided that, no, that wasn't grounds for termination.
Yeah. So as body corporates, the best way we can help you really is by providing the most complete evidence we can. It's probably not sufficient to have like a couple of people complaining. We maybe, you know, if they're complaining, they maybe need to provide witness statements to formalize that complaint. Do you feel properties that have a building or facilities manager help bridge the gap between all stakeholders, owners, body corporate managers, property managers, committees, in terms of missing information, building knowledge, and better enforcement of bylaws? I mean, it depends if that building or facilities manager is good, I suppose. If they are, yes is the answer. And if they're, you know, if they're not too interested in the overall health of the complex, then they don't really add very much. It's an extra layer of complications.
A real estate agent marketed a villa in our complex as having 2 car spaces. The villa only has 1 car space, and the second spot is a bay on common property beside the villa. This has created ongoing parking problems and tensions between the tenant and the body corporate. What can we do?
Look, that's a really tough one. At the end of the day, it falls on the agent for not advertising the property correctly. And that would definitely be something that I would be bringing up as an owner with that agent. It was obviously a misunderstanding. I don't think any agent would go out of their way to misrepresent a property in that way. But in terms of breaching the tenant for parking in that spot, if they're if a tenant can prove that it was advertised as 2 spaces and it's on their lease as having 2 spaces, then really there's not a lot within the tenancy legislation they can breach. But I would presume that, and Will, correct me if I'm wrong with this one, that body corporate would be seeking to breach the owner as the owner of the lot. Realistically, it's going to be a problem till the end of the lease and the tenant not get renewed is how I would see that winding up. But the buck does ultimately stop with the way the property was advertised, and that's why it's really important, I think, for agents just overall to know the property they're marketing and know, especially with common property, what is included and what's not. And that there is scope in tenancy agreements for inclusions and exclusions, and those things should be nominated on that agreement. So it is definitely a conversation that as an owner I would be having with the agent, and to see what kind of conversations can be had with the tenant. It may be a conversation that they go, well, I rented this property with 2 parking spaces. I'm paying X amount. If you want me to park on the street, I want my rent reduced by X amount a week, and that may be the solution in the short term. Not an ideal solution for our owner, of course, but when there's been a mistake made, that there's got to be some kind of a compensation there to rectify that for everybody, I think.
Yeah. So if you're a body corporate and you see a problem like this, I mean, the best thing to do is contact the sales agent and the owner and advise them that they're incorrect. It's a little bit different. There's different scenarios between if a property is being sold to an owner who's planning to move in and maybe a tenant who's planning to move in, because with the tenant, like you say, you can have that kind of renegotiation, perhaps with the contract after the fact. If it's someone who's purchased the property thinking that they're getting 2 car spaces and they're only getting 1, it's a case of caveat emptor, really. Buyer beware. You have individual owners. You have to do your checks and you have to make sure that what the selling agent is advising you is correct. But it's a very, very common complaint. Someone moves in and we sort of tell them, they parking space is a good example. They think they're occupying a parking space. And we say, no, that's not your space. And under Queensland legislation, when that changes in a couple of months, those vehicles can soon be towed. So people will get very upset when they think they've got 2 spaces rather than 1, and they come to us and says, well, no, look, this is the information I received from the sales agent. And I'm like, it doesn't matter to me. The only information that counts is the information that's on your CMS and the information that's on the bylaw documentation, and any information that you're receiving from your sales agent really doesn't count in these kind of scenarios. It doesn't give you any extra rights. So if you are purchasing a property in particular, or even if you're moving into a property, you do have to be very careful about what the sales agents are telling you, because there are frequent mistakes around what you're entitled to and what your rights are. And often it is way more common than it should be. People are coming in and they're saying, oh, I thought I could do this. And then suddenly the body corporate manager and the body corporate committee is saying, no, you can't. There's a lot of unhappiness, but in the end, the body corporate's almost always going to be right in those scenarios. So if you're on the wrong side of it, it's just tough luck.
Yeah, and I think you did raise a good point there, Will, about doing your research beforehand. And when it comes to tenants, they are relying on their property manager that's marketing that. There isn't necessarily a way for them to do those searches and validate that what the agent's telling them is correct, which is why, in this particular instance, obviously, the agent's going to have a very difficult situation to get themselves out of, because they're going to have an owner in a situation that's questioning, well, how did this happen? And the tenant questioning, well, you didn't advertise correctly. So it would be good if that information was more easily accessible for tenants to do their own homework, but generally speaking, they just don't have access to do those kind of checks to make sure that what's being advertised is actually what's being delivered.
Good.
And just generally, before we go, I had one more question about serving breaches to tenants. If you have a tenant that's breaching and a notice is to be served, whose name goes on the notice, and who gets notified as well? Does the owner get notified? Does the property manager get notified? What's the process?
So are you talking about a bylaw breach or just generally within the tenancy?
A bylaw breach from a body corporate perspective.
So what we usually find as property managers, we'll get notified from the body corporate manager, who's usually included the owner. So we're both being told at the same time, hey, look, your tenant is constantly parking. Here's a photo, let's use parking as an example. And so then it's up to us to then issue a RTA notice to remedy breach to the tenant as part of their tenancy, because in their tenancy agreement and in the bylaws that's provided, they are not just subject to the standard terms and conditions of their lease agreement, but also the bylaws. So we then issue that breach notice to the tenants. Then we communicate back and forth with body corporate to see if that's rectified, or, in a lot of cases, we're seeing it with our own two eyes. No, I see them again, parked where they shouldn't be. For a parking situation, as the example, any time that a tenant gets multiple breaches for the same thing within a certain period of time, we can then apply to QCAT to terminate the tenancy for repeated breaches. However, even in a strong market, an owner's going to be reluctant to boot a tenant out, because of parking. They're just going to go, well, we just won't renew them and we'll plan ahead for next time. They're not going to want to take that action for something minor. For something more serious, yes, obviously that's going to be the process that they go, but we're ultimately beholden to the owner's instructions. So while body corporates inform the owner and us as property managers this is a breach of the bylaws, we action accordingly and work with the owner. But if the owner's going, yeah, we'll just keep breaching them, we're not going to go to QCAT and I don't want to think, it's really going to come down to when body corporate then put their foot down and go, well, no, now we're going to come after you as the lot owner. That's often when they start to change their tune. So again, I think this is why it's really important that property managers and body corporate managers have a good relationship. At the end of the day, we do work for our owner, but it's our job sometimes to educate those owners in what's in their best interest.
And how does that align with the way body corporate managers breach as well?
Yeah, I mean, if we have the details of the tenant, we'll breach against the tenant, but we're always going to be, we should always be informing the owner as well. Often what we find is that if we're just going through the tenant and the agent, nothing very much happens. But if we're putting a bit of extra pressure on the owner, that's when we start to see some movement. So yeah, it should go against the tenant if you have the details, but most managers, I think, we're also going to put pressure on the owners, because that's where then the owner puts pressure on the property agent, and then the property agent puts pressure on the tenant, and that's where you see a change.
Okay, all right. Well, that takes us up to the end of the session. So thank you very much to both of you for coming on and having this very interesting conversation about ways that we may be able to all work together for a better outcome. Vicki, did you have anything you'd like to finish with before we wrap up?
I don't think so. I think just overall, it is definitely possible for property managers and body corporate managers to work together. And the important thing with doing that is remembering that we all work for the owners. It doesn't matter whether they're investors or owner-occs. Building the relationships ultimately causes less conflict. And I do think that the more education we can give to property managers and the more training we can give them about working with body corporate, the more we will see those relationships develop in a positive way. And I think that's definitely the direction that a lot of places are heading now.
Wonderful. Thank you. And Will?
Yeah, of course, it's all better if we all get along and we all try to work together. Think outside of your silo, I think is the way I would think of it. If you're just thinking like with your body corporate manager blinkers on, you're going to have troubles with agents. And agents, if you're just thinking with your agents, your blinkers on, you're going to have trouble with body corporate managers. Try to have some understanding and comprehension of how the other person is doing their job. They've probably got most of the same problems and issues that you do. Too many emails, too many phone calls, problems they can't resolve. Yeah, have some understanding of that, and hopefully you can reach a better conclusion at the end.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.